Madam Chair.
Thank you. We have a question from Representative Gerou. Mr. Blake, thank you very much. I appreciate you being here. Based on, I was approached by my constituents regarding House Bill 1361, and I think it may just need a little bit of further explanation. There's some confusion between the interaction between House Bill 1361 and the lawsuits that you mentioned. What they asked me to read is, given the legislation that was passed in House Bill 1361, why isn't the Claims Board reviewing the individual claims of the victims and making their recommendation for compensation to the victims as was the intent of the legislation? Further, it was the intent of the bill that if the victims did not accept the board's recommendation, they would then pursue their own litigation. Their question is, why are you circumventing the intent of the litigation and doing it backwards?
Madam Chair?
Yes, Mr. Blake.
Thank you, Representative Gerou, for the question. I don't want to speak to the intent of the legislation. The law, though, is clear. What the legislation did was modify the Colorado Governmental Immunity Act in a way that we back up. Prior to the legislation, the Governmental Immunity Act did not recognize fires. The government started alleged negligent fires. So there was no opportunity for any claim to be brought against the state because the state was immune. What 1361 did was retroactively waive the immunity that the state could assert. That created the opportunity for people in this room, as well as others affected by the fire, to bring a claim against the state. In addition to that, created an opportunity for the Claims Board to review claims at some point after the $600,000 cap was exhausted, and only if the maximum amount for any incident, $600,000 in this case, was completely allocated. The process that you're speaking about would in fact be the process we would follow, except for the fact that we now have litigation over negligence. That is, we have multiple claimants, all claiming different amounts of money, and so that litigation now has to run its course to finality before the $600,000 is allocated. And the board can't hear any claims until the court decides not only negligence, but how it's going to allocate the $600,000. So the board can't consider monies above and beyond the $600,000 until the court rules. Did I answer your question?